Hi, my name is Kelechi Ajoku. I'm a labor and employment associate at Hinshaw Culbertson, and we'll dive into what collegiate sports organizations should know about the latest developments concerning paying college athletes for the use of their name, image, and likeness, otherwise known as NIL. In June 2021, the NCAA implemented an interim policy allowing student athletes to profit from their personal brand, which is the birth of NIL deals. 3 years later, the policy begs the question of whether the NCAA could be considered a joint employer and how the reclassification of student athletes as employees impacts both private and public institutions, as well as the international student athletes F1 status. The NLRB ruled in February that athletes at Dartmouth College could unionize. They are the first unionized college athletes in American history. A Virginia law, effective July 1st, 2024, will now allow institutions the ability to directly compensate college athletes via NIL deals. This new law is the first in any state to prohibit the NCAA from punishing an institution for offering direct compensations to its athletes through NIL deals, though the law specifically states that student athletes are not employees. On May 23rd, 2024, the nation's 5 largest conferences and the NCAA Board of Governors voted to accept the settlement of 3 antitrust cases that will create a new structure for college sports. This settlement, which is pending approval from the plaintiffs and a federal judge, will essentially set up a revenue sharing system for student athletes and allow them to be directly compensated by the universities. Institutions should be aware that this impeding reclassification could lead to a complete restructuring of NCAA rules and mark the beginning of the employer-employee relationship between the university and the student athletes.